Imagine you have a brilliant new recipe, a revolutionary software algorithm, or a unique customer list. You keep this information secret, guard it closely, and believe it is a core asset for your business. But does simply keeping information confidential automatically make it a trade secret in the eyes of the law? The straightforward answer is no. Not all undisclosed information automatically becomes a trade secret. For information to qualify as a trade secret, it must meet specific legal criteria that go beyond mere confidentiality, providing legal protection against misappropriation. The legal framework for defining a trade secret generally requires three key elements. First, the information must actually be secret, meaning it is not generally known or readily ascertainable by others who can obtain economic value from its disclosure or use. Second, the information must derive independent economic value from not being generally known or ascertainable. This means its secrecy gives you a business advantage. Third, and critically, the owner of the information must have taken reasonable steps to maintain its secrecy. These three components work together to establish the legal status of a trade secret, often guided by the Uniform Trade Secrets Act, or UTSA, which most states have adopted. To ensure your undisclosed information becomes and remains a protected trade secret, you need to actively implement protective measures. This involves creating a comprehensive trade secret protection plan, which might include requiring all employees and partners to sign non-disclosure agreements, or NDAs, and physically or digitally restricting access to sensitive data. You should also clearly mark confidential documents and implement strong cybersecurity protocols to prevent unauthorized access. Regular audits of your information security practices are also vital. An often overlooked aspect is that the economic value does not have to be immediately tangible. It can be potential value, such as a process that could save significant costs or a design that could lead to a breakthrough product. The reasonable steps you take do not need to be extreme or exhaustive, but they must be adequate under the circumstances. This nuanced balance between inherent secrecy, economic benefit, and proactive protection is what truly elevates mere undisclosed information to the powerful legal status of a trade secret. By understanding these three critical elements and proactively implementing safeguards, you are not just keeping secrets. You are actively building and protecting valuable intellectual property for your business. This diligent approach secures your competitive edge and helps to ensure your innovations and unique business practices remains exclusively yours, contributing directly to your long-term success and growth.